Hi guys, today we're going to review the terms that we encounter on law on obligations. Okay, 1. There are 4 requisites to an obligation: passive subject, active subject, prestation, and efficient cause. When we talk about active subject, it refers to the obligor or the debtor, because the debtor and the obligor is the one that will perform his obligation. Then we talk about the passive subject, that refers to the creditor or the obligee, because the obligee or the creditor will just wait for the debtor to perform his obligation. When we talk about prestation, that refers to the object that is subject to an obligation. And we talk about efficient cause, that refers to the tie that binds both the obligor and the obligee, or the debtor and the creditor. There are 5 sources to an obligation, guys. 5, not 10. 5. These are law, contracts, quasi-contracts, quasi-delicts, and acts or omissions punishable by law. Quasi-contracts are classified into 2: solutio indebiti and negotiorum gestu. Quasi-contracts is based on the underlying principle that no one should be unjustly enriched at the expense of others. So, solutio indebiti simply means you receive something that you don't have the right to receive it, you need to return it. So, example, when you receive a change of 80 pesos, when you should receive only 50 pesos, you need to return the 30 pesos. What's the basis of your obligation to return the 30 pesos? It's solutio indebiti. Negotiorum gestu is just a voluntary administration of the property of another. Just like when your neighbor is migrating in the US and never returned ever since he went to the US, and because you are a good neighbor, you look at the house is dilapidated, so you voluntarily repair the house and incur some expenses on the repairing of the house. Then your neighbor comes. Does your neighbor has the obligation to reimburse you of whatever is incurred in the repair of the house? The answer is yes. What's the basis of the obligation of your neighbor? That is negotiorum gestu. Let's go to quasi-delict. Okay. Quasi-delict is what we call culpa alquiliana or civil negligence. There are other kinds of negligence. These are contractual negligence, or what we call culpa contractual, and criminal negligence, or what otherwise known as culpa criminal. Okay. We will also encounter the term generic thing and specific thing. Generic or the indeterminate thing, specific or determinate thing. The law only defines specific or determinate thing. The law said a specific or determinate thing is a thing that is specifically designated or particularly segregated from the rest of its class. Then we will encounter the term fortuitous event. This is a term or a topic that is hotly and extensively discussed when you took your law on obligation. What is a fortuitous event? It is an event that cannot be foreseen, or though foreseen, is inevitable. But the question is love a fortuitous event? There are 4 grounds for claims of damages. These are fraud, negligence, delay, and breach of contracts. When we talk about fraud, fraud is otherwise known as dolo. And there are 2 kinds of fraud: dolo causanti and dolo incidenti. When we talk about dolo causanti, this is a fraud that is incurred in the perfection of the obligation, and when we talk about dolo incidenti, that means incidental fraud. this is a fraud employed during the performance of the obligation. Delay, there are of three kinds. Delay is otherwise known as mora, and there are three kinds of delay or mora. These are mora solvendi, mora accipendi, and compensation mora. When we talk about mora solvendi, this is delay on the part of the debtor to perform his obligation. And when we talk about mora accipendi, this is a delay on the part of the creditor to accept the performance or payment. And compensation mora simply means delay on both the debtor and the creditor. Obligations are of different kinds. Obligations can be pure, conditional, or with a period. It can be an obligation that is alternative or facultative. It can be an obligation that is joint or solidary, or divisible or indivisible, or it can be an obligation with a penal clause. Conditional obligations are obligations that are subject to condition. And conditions are classified into suspensive or resolutory, potestative, casual or mixed, possible or impossible, negative or positive, or divisible or indivisible. An obligation can also be an obligation with a period. And when we talk about period, it simply means it can either be XD or INDM, legal or voluntary, and it can be judicial. Obligations can be extinguished, and there are several modes of extinguishing an obligation. This can be by means of payment or performance, loss of the thing due, condemnation or remission, confusion or merger, compensation, novation, annulment, rescission, fulfillment of resolutory condition, prescription, and other causes excluding menstruation. There are special forms of payment: the shonen payment, application of payment, payment by cession, and tender of payment and consignation. Novation are classified into whether it's real or personal novation, expromission, delegation, or subrogation. And as far as subrogation is concerned, subrogation can be conventional, legal, or mixed. These are the terms, guys, that we will encounter in the law on obligations. Hopefully, you can relate something, or you can think of some examples when you hear these things. So see you guys on my next video explaining the law on obligations.